Westlaw, and we now have the High Court homepage, which we actually looked at the other day as well, so it's not completely new to people. And so I will hand over to Joanna. Joanna Fear is the library manager at the Federal Court here in Queensland, and she's going to introduce you to lots of different and interesting things.
Thank you, Jill, and hi everybody. Really nice to be here. Okay, I'm going to be talking about court documents. So I guess what you focused on to date in terms of case law are judgments. And most of the research that you do as a legal researcher or a law librarian does involve judgments. But really the judgments are just the final product of what is often a very long process. Judgments are important because they state the outcomes of a particular dispute and they provide the reasoning, how the judges reached that outcome. But there are lots of procedural stages before that judgment that involve documents, so creation of documents that are then filed with a court registry. And on rare occasions, as a law librarian or a legal researcher, it is useful to look behind the judgments at the procedural stages. The times you do that, for instance, are if someone asks you for a judgment, you can't find it. You might need to look at whether it's actually been delivered or whether the matter is still before the courts. And in some cases, a matter settles or there's a discontinuation, the parties decide not to go on, and there'll never be a judgment. So you might hear that something's been litigated, you can't find an end product, so actually being able to track what's happened in the courts gives you satisfaction that there isn't a judgment in the particular matter. The other time that it's useful to look at court documents is to provide a context for the judgment. So in judgments, the judges often will write their judgments in a way that provides a fair amount of context. They'll step you through how the matter came before the courts, the evidence, the issues that were raised, the evidence they've considered, how they've reasoned it out to reach their decision. But there's a whole lot of other information that doesn't make it into the judgment that can be highly relevant to understanding the particular issues and the context of the case. So that's the reason that you may need to know some of this information that we're going to talk about now. So it gives you the backstory, I suppose, to judgments. So let's have a look at what court documents are. And really to understand court documents, unfortunately, you need to understand a little bit about court procedures because the documents fit into the way the courts operate, that they relate to particular disputes. So it's interesting as a law librarian often, or as a legal practitioner, often you look at judgments as the be-all and end-all, and you forget that they're actually disputes between two parties. People have issues that they need the courts to resolve. You also need to remember that our legal system is adversarial. So it's all about one party bringing a matter to the court and another party responding to it or defending the action, because that flows into understanding the procedures, the way it all sort of plays out in the courts. Now, the procedures, including the terminology that's used, varies greatly between the courts. So for example, the party bringing the action may be called the plaintiff, may be called the applicant, may be called the appellant. The other party might be called the defendant or might be called the respondent, but effectively it's one side versus the other. To understand the procedures, the best way is to actually look at the rules of the court. So the procedures that are followed in a particular court are set out sometimes in the legislation that sets up the court. So for instance, with the Federal Court Act, but then they're supported by extensive rules, which are actually subordinate legislation. And I guess you would have talked about
highlighted the High Court rules. We did highlight those ones.
Lovely, it's all coming together. Yeah, so they are subordinate legislation in that the Act empowers the judges of the court to develop rules that govern the process of the particular court. So you'll find the rules on the legislation sites. So for the Federal Court on the Commonwealth legislation site, and for the Queensland courts, the Queensland legislation site, but most of the courts' websites also include copies of the rules. Okay, so that just sort of sets the scene a little bit. What I thought I'd do now, because this can be incredibly dry, is actually have a look at what's available in the High Court and in the Federal Court, and talk you through a couple of particular matters and see what documents are available. And the accessibility of the documents, unlike judgments, is quite limited. So you'll see that as we work through the courts. I'm going to start with the High Court, mainly because they provide the best access for court documents. So since 2011, they've made available on their website, under this cases button, details of any of the cases that are before the courts or have been before the court since 2011. So you'll find them under the current cases. So those are cases that haven't had a final hearing, that are still sort of in process, and cases heard. So let's have a look at an example of cases heard. Now, the court, this is where understanding the procedure is really important, and also understanding the jurisdiction of the court. So with the High Court, there are a number of different ways that matters can come before the court. Most of us would think about the High Court as being the top of the hierarchy, and that matters get to the court having gone through lower courts. So having come from, say, a Supreme Court or a Court of Appeal. But the High Court does actually have some what's called original jurisdiction. So some matters can actually start in the High Court. So I'm going to use one of those as an example. And you'll see along the bottom here, you've got an A to Z. And it's just as easy as clicking on the letter representing the parties' names. And I'm going to use a Clive Palmer case. So this is Palmer and Ayres. Okay, so open up the page and you'll see there is a list of information with hypertext links. So it tells us a little bit about the matter, and then it gives us a list of documents. Now I've got this scroll issue, but let's just work through it. So it tells us that on the 12th of September, a writ of summons was filed with the court. So the writ of summons is the way that this particular action commenced. Now this action, the plaintiff is Clive Palmer, and there's another man too called Mr. Ferguson. They were both directors of Queensland Nickel, which is being wound up. The defendants, so the people that the action's being brought against, are the liquidators who are doing the winding up. Basically what happened was the registrar of the Federal Court summoned Palmer and Ferguson to attend court and to be examined under oath, and there's a power in the Corporations Act that allows them to do that. But Palmer and Ferguson brought proceedings in the High Court, basically challenging the constitutional validity of that section of the Corporations Act on the basis that that power wasn't a judicial power and therefore shouldn't be exercised by the court because of the separation of powers. So constitutional challenge. So it started in the court with this writ of summons. Now you notice that there's no hypertext link, so that document's not available to us, but at least we know that it was filed in the court on the 12th of September. On the 12th of September, there was also this notice of constitutional matter filed by Clive Palmer. Whenever there's a constitutional issue brought before the High Court, there's a piece of legislation called the Judiciary Act, which says you have to serve notice on attorneys general throughout Australia, so the Commonwealth Attorney General and all the state attorneys general, to say this matter's on foot, and that gives them an opportunity to intervene, so to become a party in it. So it tells us that that happened on the day that they filed their writ of summons. Then there was a hearing, and you'll notice that here is where the hypertext links start. So this was a hearing before a single judge, and this is what's called a directions hearing. And you'll notice that this opens up a document which is actually linking out to Ostly, but this is the transcript of what was said in court during that directions hearing. And it looks a bit like a script from a play, because it's got the various players and what they said, including the judge. So you're actually able to read what went on in court on that particular day. And directions hearings are pretty dry. They're basically just working out what has to be done, the judge setting deadlines that the parties have to meet, setting dates, and sort of clarifying the issues. But that's information that is available to you freely to read if you are so inclined. Now, I just need to close that one. Or maybe I'll go back here. Okay, the next document that's available to you are the written submissions. Now, this is all set out in the rules. Written submissions in the High Court can't be more than 20 pages long. And this, if we open it up, is a PDF of exactly 20 pages.
Like an assignment.
So I don't know if they decreased the font or what, but what it does is clarify what is being argued. So it's a statement of the issues that form the basis of the action. It's a narrative statement of the relevant facts. It highlights the applicable legislation. It sets out the orders that the party's seeking, so what they want the court to actually do for them. And it estimates the number of hours that it's going to take them to present their argument, which helps the court then schedule things. The next document that's filed at the same time as the submissions is a chronology, which again is a really useful document because it steps you through the principal events that led up to this litigation. Then you'll find there was another directions hearing. And again, you link out to the transcript there. And then a few days later, written submissions were filed by the defendants. So those are the liquidators. And four attorneys general decided that they would intervene. So Commonwealth, Queensland, Victoria and South Australia intervened, and they've provided written submissions too. So remember the adversarial aspect of it. So basically the party bringing the action has to be upfront about what they're trying to do, and then the others respond to that. And then lastly, the plaintiff has a right of reply. So that document is the reply. So that's all the lead up to the actual hearing, which happened on the 10th of November. And you've got two options to inform yourself about this particular hearing. You can look at the transcript, which is 3 hours worth of transcript. Or if you prefer, you can watch it as an audiovisual recording.
With no ads.
With no ads. Now, this is a pretty interesting one because, and a little bit unusual, because if you look at the transcript, and if we go right to the end, and as I say, this is 3 hours worth of transcript, so it's pretty long, you'll find that right at the end, so at 3:40 p.m, there was a short adjournment, and then at 3:45, so 5 minutes later, Justice Kiefel, who was the senior judge of the court, came back and said, the court is unanimously of the view that the question reserved is answered no. So the court basically decided straight away that the proposition that the plaintiff was bringing was wrong. That's unusual. Usually the court will reserve their judgment, and it will be some weeks usually before you get an answer. But in this case, they came back and said no immediately. However, you'll notice it does say that matter was adjourned and reasons for judgment to be published at a later date. So there will be a written judgment, but it hasn't come down yet. When the judgment does come down, you'll find a link to it here. So there's an example of what you get for the High Court, which is quite extensive information. Now,
When you say that's only since 2011 that they've been that
yes,
transparent?
Yes. So just going back to the court, so in terms of cases that are current, we'll just have a very quick look. So anything that has not been heard, but that the court has accepted to hear, and you do need to bear in mind, so we've looked at something that came before the court in its original jurisdiction. A lot of what comes before the court are in their appellate jurisdiction, and not everything you can't just apply to the court and have an appeal heard. They actually only select decisions that are really important to look at. So if there's a question of law of public importance, or where there's some difference between the courts, maybe the state courts disagreeing, or there's a different opinion in a federal court and a state court, so resolving those sort of differences, or in the interests of justice. So that usually if there's an appeal, they go through a special leave process. On the site, they do list the special leave application results, so you can see that there. But the matters that are before, that have got through either the special leave process or a couple of other really relevant topical cases, I suppose, are these cases that are actually a different jurisdiction, again, of the High Court, and these are the Court of Disputed Returns cases. So these are the cases where the senators right to be senators are being challenged. Yes. So this is Cullerton, who is the One Nation senator. So this is a question that's come from the Senate. So you'll see here the question was referred by the Senate on the 7th of November. The 21st of November, there was a determination. Again, this is a little bit sort of directions. And there was an order made by Chief Justice French in terms of setting things down for hearing. So even where something is at the early stages, it's useful to look at the website because it will give you some sort of idea of the scheduling. So this doesn't tell us when it's going to be heard, but it does tell us that written submissions are due on the 25th of November and the 30th of November. So it can give you a bit of a prompt for what's coming up and just the status of things. So that's the High Court. And as I say, the High Court probably gives you the most access, the greatest access to court documents. Other courts, less information available. There are a number of reasons for this, I think. One is that they're of less public interest, I suppose. What gets to the High Court is the really important issues. The things that get to the lower courts are often very humdrum. You know, they are just disputes between individuals. There's nothing really interesting or groundbreaking about them. So you don't want all that stuff cluttering up cyberspace, I suppose. There's also a much greater volume in the other courts. So the High Court doesn't hear that many matters. So I had a bit of a look at their annual report. 2015-16, 795 matters were filed and they delivered 54 judgments. Compare that with the federal court, where we had 5,992 matters filed and 1,776 judgments. So just much bigger volume. And the other thing about the High Court is because that they tend to be hearing matters that are matters of law, whereas the lower courts are really, there's a lot of factual decisions being made. What the information that's put in evidence before those courts is very personal in a lot of cases, so it's probably not appropriate for it to be sort of more widely dispersed. So that the courts try to balance the important principle of open justice with the interests of justice, which also include confidentiality and privacy. So, having said that as a justification for why not much is available in the other courts, let's have a look at the Commonwealth Courts portal. So this covers the Commonwealth courts other than the High Court. So it's the Family Court, Federal Court and Federal Circuit Court. Now this portal, if you are a party, you can register and you can get access to the file on the matter that you are a party to. So obviously parties have greater rights than just the general public. However, there is an opportunity for anybody to use this federal law search without registering. And it does give you a little bit of an insight into what's happening before the courts. So it provides you with quite basic information, but let's have a look at what that looks like. So if you've got a file number, that's the quickest and best way to get to a particular matter, or alternatively, you can do a party search. And I'm going to be a bit controversial here.
Know where we're going with this one.
Well, it's topical. So I'm going to search for Queensland University of Technology as a party before any of the federal courts, and let's see what we come up with. There we go. Okay, so we've got a list there, and the one that I'm after is this one that's so controversial. It's so much in the news. It's about 18C of the racial discrimination. Okay, so let's have a look at what we can find out about this case, and I'm sure everyone knows a little bit of background from the newspapers. So let's see how this ties in with what's available on the court site. So what you will find is you can get some parties' names. So you can see who the parties are, and you can see who they're being represented by. You can have a look at a list of documents that have been filed in the matter. But you'll notice there are no hypertext links. So basically it's just stepping you through the stages in this action. So, and giving you dates and things and who filed the particular documents. So the application was brought on the 20th of October. There was a response by one of the parties on the 18th of November, a notice of discontinuance. So that was by the applicant. So I think that was being reported that there's been a settlement for some of the parties. The statement of claim, again, this is where clarifying the issues. Affidavits, now affidavits are sworn documents, and this is where there will be evidence sworn in a documentary form. So this is all kind of building the case. And you'll notice various additional documents have been filed. A subpoena, so requiring the production of documents, the production of information, and various other documents. So it's fairly bland what you're getting. You know who's involved in the action, you know where it's at, you know that it's still on foot because the status is open, and you know the type of matter it is, but you certainly can't, on the net, get access to any of these documents. Okay, then the other link here steps you through the court events. So that's everything. The first lot is everything that's happened in the registry. This is what's happened in the court. So again, reverse chronological, so starting with the first court date. And you'll notice there are some hypertext links here, and they take you to orders that have been made by the judge. So the first court date, the orders would have been very directional, setting timeframes and things. You see that the terminology here, hearing of an interlocutory application. Now, interlocutory is a term that's used a lot in court processes, and basically it just means not final. So there are lots of stages, lots of toing and froing with the courts before you get a final decision, a final judgment, and that's all that interlocutory means. So yes, you can view the orders, and if we open one, you'll see that they are quite scant compared to what you will see with a judgment. It's fairly sort of procedural. So this is the latest. This was before the court this week. So basically the court's allocated 4 days for hearing in March, and an application for certain things has been adjourned to the 9th of December. So if you were, someone had asked you, where is that case? Where is that, the QUT case for 18C? Where's it at? Because when you read the papers, sometimes it's a little bit ambiguous. It sounds like it's over. But if you look here, you get the full details of where it is at, what's coming up perhaps, and just, what to be aware of. So that's what's available online, and as you see with courts other than the High Court, it's not very much, and there are good reasons for that, but there are ways to access those documents, and it's basically depends on whether you're a party. If you're a party, obviously it's easier to get access. The media also has easier access. That's why some of these things are reported. Also, the media sits in court because obviously it's an open court most of the time, so you can actually go and hear these things. It depends on the type of document. So the things that are restricted tend to be things like affidavits, exhibits, unsworn statements, subpoena material and confidential material. But what you can get access to, you actually have to apply to the court. And you have to pay a fee, and the fee is set out in the rules, and it can be quite hefty. So it's a $50 fee just to get the file out, and then if you want copying, it's $1 a page. Now that's just for the material that's on the court file. If you're wanting the transcripts, so when we looked at the High Court page, you saw that there were transcripts readily available there. One of the reasons for that, I think, is that the High Court actually still has court reporters. But a lot of the courts have outsourced their court reporting to, and in Queensland it's to an agency called Ausscript. So if you're wanting a transcript, you actually have to apply through Ausscript, and their fees are quite hefty. Right. Yes. And when you consider, you know, that it can be days and days, like that particular matter set down for 4 days, can you imagine how many pages of transcript it is? So yes, it's not easy, and it's not fast, and it's not cheap. Yeah. Now, there are some exceptions to this. With the federal court, I'll just show you very quickly, there are some files that have been considered so important, usually because the high profile, the court's getting a lot of requests for this information, that the court or the particular judge decides to make the whole file available. And as an example, on the federal court site, you'll find under services, down here it says public interest cases online files. So if you click on that, you'll find that there are 4 files that have been made completely available. So there are things like, so this is Craig Thompson and the Health Services Union dispute. This was the racial discrimination issue relating to the police and the Palm Island riots. And these were the Essendon football doping issues. But if you look at these, you'll find you know, things that you won't get generally on the net. So, you know, interlocutory applications, the actual statements of claims, affidavits. Yeah. So there are rare occasions. And of course, the other time you'll be able to get that sort of information if it's historical. So if it's a file that's, you know, in the archive and has passed the date of it being not available for public release. So if you're looking at a historical file, it might be easier. When I was thinking about this, it suddenly occurred to me the other type of court document that often you're asked for as a law librarian is sentencing remarks. So what I've focused on so far are civil cases, so cases involving private parties. But in criminal cases, the court document that you're most often asked for would be sentencing remarks, and they can be very difficult to come by because they're not part of the judgment. They're the words that the judge spoke when sentencing a person. They're taken down as transcript, and their availability varies according to the court. So for instance, in Queensland, the Supreme Court makes available a selection of sentencing remarks, and they're selected by the judge because of their particular significance or public interest, and they're available on the Supreme Court Library's website for 3 months, and then they're taken down. Whereas the ACT put everything, I think, since 2010, so it really does vary. And I guess that's the message with these court documents. Depends on the court, depends on who you are, and it depends on the you know, the matter and the documents. But certainly they're worth considering because they really provide the behind the scenes of what happened in the judgments, and it's all real. There are no advisory opinions, so it's all about individuals, you know, taking a matter to court. So I hope that's been useful. And yeah, please explore these sites. Any questions?
This all started, I probably need the microphone, but yeah, thank you, Joanna, very much. This all started, I think, with one of the questions on Facebook early on in the course, that somebody wanted to know a lot more about this sort of site. So hopefully we've met your learning needs that way, and it's been a delight having Joanna to sort of share an amazing amount of experience and a lot of things I didn't know very much about.
One important thing that Joanna did say too is that you don't always get a judgment. So when I was a litigator, a lot of the strategy was to try and not get to court not go through a trial, because the minimum was about $20,000 a day in terms of fees that would be clocked up for the client. So we did everything but try and get to court. So we'd have earlier settlements, summary judgments, default judgments, mediation, directions, hearings. So if you're looking through those court documents and all of a sudden it ends, then that's the reason why, because the strategy was trying to get rid of it quickly and to save a lot of costs and to settle it. So it was a very good point that Joanna said. Yeah.
That's great. Thank you, Lisa. That's really good extra sort of information all around this. Okay, if there are no questions at the moment, we'll mull it over, and obviously we've got access to these brains and through email. And so if you do have any ideas or questions or comments that come, we can sort of work with it offline then as well. So that would be really great. So, but at that point, I think we've done very well. It's been an interesting evening, and it's been quite different having everybody in the same room. So hopefully you have enjoyed it your end as well. Same time next week, and it's the final week next week. In fact, it's week 8. And so Joanna, I think, is coming back. We've got Joanna on a panel with Alex Cato, who's was with us early on, and she's the current president of ALA, as you know. And there may be another couple of guests as well. We're just working on that. So it's very much about pulling together all of the different aspects of the course and how it all fits into the real life of the law librarian and the career structure and things like that, and the directions you might be able to go. So enjoy the rest of the week. If you're working on your assignments, hope that's all going all right. Let us know if you've got any problems. But otherwise, we'll love you and leave you, and see you next Wednesday. So thanks again to our guests, and we'll see you all soon.